The courtroom didn't react the way people expected. There were no shocked voices, no sudden noise. Instead, there was silence. And in that silence, something important shifted. It was the kind of pause that makes everyone in the room aware that a line has just been crossed. A moment when the tone changes, not loudly, but permanently. From that point on, things could not return to how they were before. Today, on WW2 Unlolled, we take you inside that exact moment. Not a media headline, not speculation, but the instant when the court stopped listening emotionally and started listening carefully. Until then, Prince Harry had been speaking as someone sharing a deeply personal experience. He described the pressure of constant media attention and how it affected his life and his family. His words carried emotion, and the courtroom allowed space for that. Many people watching could understand his frustration. His account felt sincere. The atmosphere reflected that. But courts don't operate on emotion. They operate on clarity, consistency, and evidence. And that is where everything began to change. The shift didn't come from a dramatic objection or a raised voice. It came from a calm, straightforward question. One that didn't ask how he felt, but what he knew. The court asked when he first became aware of how certain information might have been obtained. At first, the question sounded ordinary, administrative even, but it required precision, and that precision exposed uncertainty. Prince Harry hesitated, only briefly, but in a courtroom, even a brief pause can matter. Up until that moment, the court had been hearing a story. Now, it began examining a timeline. Stories move forward naturally. Timelines must align perfectly. As the questioning continued, the judge didn't accuse or confront. Instead, the questions became narrower. Dates mattered. Details mattered. Past statements were compared with present answers. The tone shifted from listening to verifying. Prince Harry's responses became more emotional as the questions became more specific, and that contrast is something courts are trained to notice. When confidence slowly turns into qualification, credibility can quietly weaken, not because someone intends to mislead, but because memory and interpretation begin to blur. This is where many witnesses struggle. Emotional pressure doesn't always strengthen testimony. Sometimes it complicates it. And that led the case into its most sensitive phase. As the questioning continued, something important remained unchanged: the documents. Written statements don't tire. They don't adjust themselves under pressure. They remain exactly as they were when they were signed. The court had Prince Harry's own written submissions in front of it, carefully prepared, reviewed, and approved. In those documents, the language was firm, clear, confident. They described a belief at the time that improper actions had taken place. But now, speaking under oath, without guidance in the moment, Prince Harry was asked to explain those statements. Not reinterpret them, explain them. This is where the concept of hindsight became central. His answers suggested that his understanding developed gradually over time, that suspicions formed first and certainty came later. That explanation might sound reasonable in everyday conversation, but in court, timing matters. The judge focused on one key issue. Was this belief something he held then, or something he understands now? That distinction matters legally. When present understanding reshapes past memory, courts become cautious. Not because emotions aren't real, but because claims must be grounded in what was known at the time, not what later reflection brings. As the judge summarized Prince Harry's answers back to him, each agreement narrowed the space to maneuver. Each confirmation fixed the narrative into something more rigid. Then the court turned to earlier events, years earlier. Not out of curiosity, but because those moments were referenced in the legal claim itself. Articles from a previous relationship were discussed, not to revisit personal history, but to examine consistency. Prince Harry spoke openly about the emotional impact of that time. His descriptions were clear, familiar, and heartfelt.
But then came the crucial question. At that time, did he believe the information had been obtained improperly? His answer was careful. He explained that he was young then, that he didn't fully understand how media systems worked, that while he felt something was wrong, certainty came later. And there it was, a difference between what was written and what was now being said. In writing, the belief appeared immediate. In testimony, it appeared gradual. The court highlighted this gap, not with accusation, but with comparison. This wasn't about emotion, it was about alignment. As the judge returned to specific examples from the past, the pattern became clearer. Feelings were remembered vividly. Conclusions formed later, but were described as earlier. That difference became central to the court's evaluation. And in that moment, the case stopped being about public attention and became about reliability. The silence returned. Not dramatic, not loud, but decisive.
At the center of the problem was a simple issue. He couldn't say yes because he didn't actually know. And if he didn't know, how could he sign a legal document stating that he did? This wasn't just about forgetting a detail. To many watching closely, it looked like the past was being adjusted to fit a legal claim. As discussion of earlier relationships faded from the courtroom screens, a far more serious concern began circulating among legal observers. Not emotion, not regret, but the question of whether sworn statements still aligned with the facts. This tension defined the entire trial. Prince Harry entered the courtroom relying on a strategy some experts later called a memory gamble. To understand why it failed, you have to look at the world he had been living in for years. A world shaped by interviews, documentaries, and personal storytelling, where feelings are treated as truth and emotional experience carries authority. In that environment, memory is often described as flexible. If something feels real, it is considered valid. But courts operate very differently. A courtroom is not a publishing house. It doesn't curate experiences, it tests claims. Judges understand that human memory fades over time. Small gaps are normal. But there is a line, and the court began to sense that line had been crossed. What raised concern was not what Harry remembered, but how his memory behaved. When speaking about emotional pain, his recollections were detailed and vivid. He could clearly describe how articles made him feel anxious, targeted, overwhelmed. But when questions turned to concrete details, dates, documents, and actions that would prove wrongdoing, his certainty weakened. This uneven clarity caught the judge's attention. Why were emotional memories sharp while factual ones became unclear? And more importantly, did that uncertainty appear randomly, or did it surface only when the answers carried legal consequences? Harry seemed to assume that his position as a harmed party would bridge those gaps, but the court was doing something else entirely. It was tracking patterns. As questioning continued, a clear trend emerged. Whenever facts challenged his claim, his language softened. Phrases like, "I believe," "I think," and "to the best of my recollection" became more frequent. In personal writing, that sounds honest. In court, it creates risk. The judge then used a word that subtly changed everything: concerns. To most people, that sounds mild. In legal settings, it is anything but. It signals that the court has identified an issue serious enough to demand attention. The judge pointed to differences between written statements and spoken testimony and described them as material. That word carries weight. It means the issue is not minor. It affects the foundation of the case. At that moment, Harry's strategy unraveled. He had arrived expecting to challenge the press. Instead, his own reliability was now under examination. The emotional tone that once worked in his favor was gone. He was no longer presenting his story. He was being measured against it. The judge did not accuse him of dishonesty. He didn't need to. By identifying the inconsistencies as material, the court opened the door to a much more serious discussion. A word entered the space, quietly, never shouted,
never dramatized, but powerful enough to shift the entire atmosphere. The judge explained that when testimony under oath conflicts with earlier statements, the court has a responsibility, not to punish, but to protect the integrity of the legal process. Then, he addressed a possibility that had been lingering unspoken. He did not say wrongdoing had occurred. Instead, he stated that the inconsistencies raised the question of whether the matter might meet the threshold for referral. To outsiders, that sounds technical. In reality, it is one of the most serious signals a civil court can send. It means the issue may fall outside the current case and into the hands of prosecutors. This was the moment the trial changed shape. It was no longer about media conduct or privacy. It became about accuracy under oath. The judge clarified that if there is a realistic possibility that evidence was knowingly inaccurate, the court must consider further action. That phrase, realistic possibility, sits between speculation and certainty, and the judge had just placed Harry's testimony inside that narrow and dangerous zone. Harry remained outwardly calm, but the stillness in the room was unmistakable. Public sympathy no longer mattered. Narrative protection was gone. The judge emphasized an important distinction. Legal consequences are not triggered by confusion or honest error. They arise when statements on important matters are knowingly incorrect or made with disregard for accuracy. By highlighting the contrast between written certainty and spoken uncertainty, the court identified a potential problem that could not be ignored. The judge concluded carefully. No immediate action was taken, nothing was finalized, but the warning was clear. The case was left suspended, not closed, not escalated, yet the damage was already done. Once the possibility of referral is mentioned, it doesn't disappear quietly. As Harry left the courtroom, he did so under a cloud of uncertainty, and that uncertainty doesn't stop at national borders. Credibility travels. If a high court signals doubt about sworn testimony, that doubt can echo elsewhere. Observers have already noted that this situation could intersect with questions raised in other jurisdictions, including ongoing scrutiny of past disclosures. From here, the story becomes bigger than one courtroom. There is a deep irony in all of this. In trying to take control of his story, Harry may have weakened his position. Personal truth can sell books, but only verifiable truth survives legal examination. This case reminds us of a difficult reality. Pain does not replace proof. Feeling wronged does not establish facts. Now the judgment shifts to the public. Was this a case of confusion under pressure, or was history reshaped to support a claim? That decision is yours. If you value careful analysis and honest discussion, support the work. Stay engaged, because while this chapter may be paused, its consequences are still unfolding.